Welcome to A Case for America. I am Austin Hepworth, and I'm here along with Michael Hepworth. Today we're going to be talking about the 14th Amendment Privilege and Immunities Clause. As we've mentioned in previous episodes, the 14th Amendment has quite a few provisions in it, and they don't necessarily all work together perfectly with how the courts have interpreted them, or the courts have assigned some interesting interpretations to them. So with this Privileges and Immunities Clause and looking at it, naturally, the question comes up, what is a privilege or immunities? What are we talking about? So the 14th Amendment says that no state, so no individual state, shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. And so we have this provision, and this is clearly a restriction on the states. So if you remember the Bill of Rights, the first 10 amendments, they were restrictions on the federal government, on Congress. The 14th Amendment is coming in, it's putting some restrictions in place on the US as a whole, but it's also clearly targeting states when it says no state. So no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So on its face, when you look at this, to me, it seems to suggest that states can't pass laws that take away your privileges or immunities or maybe rights that are associated with being a citizen of the United States. Prior to the 14th Amendment, prior to the Civil War, states could restrict your freedom of speech. States could restrict your freedom of religion. States didn't have to follow the Bill of Rights. And so you could have rights guaranteed by the Constitution at the federal level, meaning Congress can't do something, but the state could still say, yeah, we don't really care about those. We're going to do whatever we want. And we saw something like that situation with when Missouri issued an extermination order against the members of the Church of Jesus Christ of Latter-day Saints that lived there. They didn't like the church or its members, and they issued an order for all of them to be driven out of the state or killed. And that was something that was a state action. As Missouri State, it wasn't the federal government. So the federal government said we can't do anything because states can do whatever they want, basically. There's not really these limitations on them. So the Civil War comes up. After the Civil War, we get the 14th Amendment. And then it says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. To me, that sounds like this is attacking the situation where a state has chosen to do something that violates something in the Constitution or something guaranteed to citizens of the United States. And it sounded this way to other attorneys as well, and there were court cases filed on this. And so we had what they call the slaughterhouse cases, where I think it was Louisiana was getting upset about pollution from animal slaughterhouses. And they eventually just kind of took over the slaughterhouse industry, created a state-sponsored monopoly. And the slaughterhouse owners sued, saying it violated their privileges or immunities of citizens of the United States, because they said, we have a right to work, essentially, right to do these things. And when the Supreme Court came and looked at it, they said, we're not really going to give much life to this sentence. It doesn't mean a whole lot. And they basically came down and said, it guarantees a couple things. It guarantees the right of access to the seat of government, to seaports, to courts of justice. It gives you the right to demand protection of the federal government on the high seas. It gives you the right to assemble, so states can't take that away. And if there's any rights secured by treaty, then no state can take those away from you. And then in addition, the court has over time looked at a few other rights of US citizens and said, yeah, you have the right to pass freely from state to state. So states can't stop you from doing that. You have the right to petition Congress, the right to vote for national officers, the right to enter public lands. They found a right to be protected against violence while in the lawful custody of a United States Marshal. And then the right to inform the United States authorities of violations of its laws. So that case, I don't know what led to that case. Kind of curious to know when the US didn't want to know about violations of its laws. But apparently there was something had to be fought over that. And then the court also had kind of mentioned a right to carrying on of interstate commerce. Now, this again comes kind of after a slaughterhouse when these businesses are getting shut down, taken over by this monopoly. But it's interesting, this notion that was the 14th, or this question of, was the 14th Amendment intending to apply the Bill of Rights to the states? Was America looking at itself and going, you know, this slavery stuff, this religious stuff, we've had some pretty strong abuses by states, and we're getting kind of tired of that. So it's time that we take away some of these states' rights. The court in the slaughterhouse cases was very reluctant to say that the Bill of Rights applied to the states. They were kind of, whoa, that'd be a pretty sweeping proposal to suggest that. And they shied away from it. And they said, no, it's just these couple things that are just, you only have a few rights guaranteed as US citizens, and that's all that this is talking about. This is one area I feel that the court got wrong, personally. The court reached its opinion by going through and looking at the Constitution. So they asked the question of, well, what do privileges and immunities mean? And it's an important question to ask. But they asked that question, and they go to the US Constitution, the original Constitution, prior to any amendments. In Article 4, Section 2, it says the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. So instead of saying in the United States, it says in the several states. But it has this privileges and immunities clause. And so the court looked at it and said, well, can it mean the Bill of Rights? And then they said, no, because the Bill of Rights didn't exist when the original Constitution was passed. And because the original Constitution used the term privileges and immunities, then there's no way it could mean the Bill of Rights. And the people that passed the 14th Amendment were using language that already existed. And so therefore, we're going to stick it to that original meaning and not have it be the Bill of Rights. So Michael, I'm curious what you think about the Supreme Court's interpretation there, or if there's other ways that the Supreme Court could have looked at it.
Yeah, it's a tough one because I kind of see where they're coming from. They say the same words are used, therefore let's look, because we maybe can't find a good definition today, let's look at maybe what they meant when they originally wrote it. I think it's overlooking something, though. I think it's overlooking what amendments might mean to the Constitution. If you write something into the Constitution and then you alter that with amendment, you probably need to look to that amendment as to what it now means. Now, the argument could be that when the Bill of Rights was written, it wasn't applied to the states. It was just applied to the federal government. And so the privileges and immunities still wouldn't apply to states at that point. But I think it could be argued that the Bill of Rights did alter that, as it just wasn't applied at that point. And the 14th Amendment made it clear. I think there's probably a lot of ways to look at it. And I think this is probably one of the issues we have with law and the nature of language. We have ways to communicate, but different words can mean so many different things in different contexts, and the same word can mean a different thing at different times. And the law is just left to try to figure out what somebody meant at one point in time. Maybe they had some documentation about why they wrote what they did. You could maybe argue that the documentation isn't valid because it's not law, and we just have to look at the law written itself. But it comes down to interpretation, and how do you interpret the way they wrote this out? You have the same word existing in the Constitution. You have the same word existing in the 14th Amendment. Do they mean the same thing? Was the 14th Amendment written that way to say, hey, we mean the same thing as the Constitution originally, or was it written that way to say, hey, this is applying to all the privileges and immunities that have been added since that time, including the Bill of Rights? I think you could probably argue for a very long time about it, and maybe when we just can't be clear enough in our language, maybe we can start to look to another source. We've talked about morality in law and how it needs to be applied as kind of an ultimate authority when it comes to the Constitution. I think this is a great example because at some point, everybody is going to have a different opinion on this. And then so you say, well, how do you decide which way it is? Do you vote on it? Is it a democracy? Is it left up to the judges and their democracy on the court to just decide how they feel about it? Can we do anything better than that? And I think this is one key area that morality can play a part in the law, where you can say, what should it be? How should this apply? What is the way that if we're seeking out freedom for individuals and for this country, how should we apply the way this is written to the law today? So I think we could probably look to morality as a good second option there. Because again, as I walked through this and you helped me walk through this, I was just confused as anybody, and I thought, wow, you can look at it a lot of different ways. And I just kept thinking, how should this be applied? What would be the way that would best protect liberty?
Yeah, and it is really interesting when you're an attorney. I think one of the most impactful things I learned in law school that really has helped me in how I approach life right now is I learned that all the quote experts are humans just like me. And sure, there's things we've learned, but my first job out of law school was doing campaign finance work. And I remember one time sitting in a room with quite a few attorneys who had specialized in campaign finance. And we were trying to figure out what a provision of law meant. And there was almost universal disagreement among everyone. There were so many ways you can interpret it. And it's a tough job when you have to then tell your clients, well, this is what you got to do. The law says this, and here's 10 attorneys that disagree on it. But it really helped me understand that there's, to this point about language alone, the language alone never gets us there. And no matter how many experts you put in a room or how many attorneys you put in a room, they can argue for all types of things. And if you look at this privileges and immunities of the 14th Amendment and say, what does that mean? There were attorneys arguing this means the Bill of Rights applies to the states because it says no state shall abridge the privileges or immunities, make or enforce any law that shall abridge these privileges or immunities of citizens of the United States. And they go, that's clearly talking about the Bill of Rights. These are privileges that people have as part of being a U.S. citizen. And then there's others that say, no, it can't mean that because that's the same term used in the original Constitution. The Bill of Rights didn't exist then. And so to your point then, well, how do we decide which interpretation controls? Is it an appeal to logic? Is it appeal to justice? What's the moral principle that's guiding us in these decisions? And one of the most disappointing things to me about the law and judges is they won't articulate, many times they won't articulate the moral basis they're going off of. They pick a rationale or they pick what they feel is the better interpretation, but they often don't state their underlying rationale for it, their underlying moral basis that they're relying on to achieve that. And then we have cases where there's precedent and the precedent builds based on language. But if we understood the underlying principle that caused us to hold this way, we'd be able to argue and articulate, advocate for things much better. But in constitutional work, we often shy away from admitting there was a moral basis for what we did. Now, there are cases where judges they've been very clear from a moral perspective why they're doing that. And I really respect those cases. But in this situation, the court just kind of said, I don't think so. That's a big change. We don't think America's ready for that. And we'll have a bunch of states mad at us, even though they ratified this amendment. And so they eventually said no. But from a moral perspective, to your point, when we talk about what's really the supreme law of the land, is it the Constitution and what's written? Or is it that we're always searching for some higher moral principle to guide our interpretation? Over time, the Supreme Court has decided that almost all provisions in the Bill of Rights apply to the states and bind the states, meaning no state government can violate our federal constitutional rights. But the court didn't get there through this Privileges and Immunities clause. They really doubled down for the most part on the fact that they said no to start out. And they adopted it under the provision in the 14th Amendment that states that no state shall make or enforce any law, or let's see, so that no state shall deprive any person of life, liberty, or property without due process of law. So this concept of due process is another one where there's intense moral considerations associated with how this is interpreted. And due process is just this big nebulous term. What does it mean? The process that you're due? Well, what determines what you're due? Is it just what's written in the Constitution? Because if it's just what's written in the Constitution, then why would we say you can't take our stuff without due process of law? Because obviously you have to follow the Constitution. And so courts have kind of looked at it and said, it's got to mean something besides just the Constitution. What does it mean in principle? And they've gone in, and we'll get into this more when we talk about due process in depth, but they've gone through and found some deep moral concerns with things that were taking place. And this due process of law clause has led to many, many court decisions, including Roe versus Wade, the abortion decision, where the court was looking to some level of morality to say what should or shouldn't be the case. And with due process of law, it's ultimately where the Supreme Court has come down and said, yeah, the states, the 14th Amendment actually did apply the Bill of Rights to you. But it took us as a country, it's taken well over 100 years, almost 150 years, not quite that much, to fully articulate what amendments apply to the states and to hold that some of them don't. So, for example, the requirement that there be a grand jury for indictment of a crime, that one doesn't apply to the states. They felt that wasn't a necessary part of due process of law. And so there are some states that can bring criminal charges against you without presenting it to a grand jury first. And so we end up in this interesting place in America where what people argued for, the application of the Bill of Rights to the states, ultimately came to be, but it took well over 100 years to get it there, and under a different provision of law than probably what it should have been under. And that then opens up the due process, that it greatly expanded the meaning of the due process clause and gives the court a lot of power to then tell states what they can or can't do. And so it was interesting to see how this one rolled out. And I think that one of the takeaways is that when we aren't fully honest in our initial blush over of things, and then we realize we're wrong, but won't admit we're wrong, and we then come up with another reason why something should be that way, we got to the right result. but you relied on the due process clause, and that then expanded the due process clause significantly. And this is something that I see happen in politics, where people want a certain end or they want a certain thing to be done, and they'll adopt any measure necessary to do that. But fairly often it greatly expands the scope of something else that's possible because we rely on an inappropriate vehicle to accomplish something. And when we do that in the law and make the ends justify the means, those means start to expand and allow for pursuit of other ends. And obviously some agree with the court's decision on things like Roe versus Wade. Others disagree with it. But to me, to argue that the due process clause prohibits abortion, I think is fairly expansive. I think there's other rights people could have argued, even Ninth Amendment type rights. But the court didn't house it there. And because of the 14th Amendment and it applying it to the states, one thing to know about the 14th Amendment and the Bill of Rights being applied to the states is it made the Supreme Court far more powerful than it was in the beginning. Because the Supreme Court in the beginning could only talk about federal action. It couldn't tell states they were wrong, generally. And so a state could do whatever, and the Supreme Court couldn't do much to it. But when the Bill of Rights began to apply and the due process clause was used to overturn state action, the Supreme Court gained a lot more power at that point. And of course, the founders of the, sorry, not the founders, the drafters and those that passed the 14th Amendment, by that time, the role of the Supreme Court was well documented in America. They passed it understanding full well that the Supreme Court would be deciding the 14th Amendment. So it's not like this was something that the Supreme Court just jumped out and said, ooh, we get more power today. Because even, again, in the slaughterhouse cases, they rejected the proposition that they now had the power to control the states. And they said, no, we're not really comfortable with that. And they turned that down. But over time, again, the morality of it, the argument for it was very hard to avoid. And so they adopted it. So it's an interesting look in history. Again, the Privileges and Immunities clause today doesn't mean a whole lot because in general, there's not laws restricting you from seaports or doing a couple of these different things. Even if you have a violation of the right to assemble, which they say is protected by this, you sue under the First Amendment and not this amendment as much. And so it's a little bit of an interesting historical artifact, but I think it's useful to look at and very useful when we talk, like you say, Michael, about the morality side of things. What should be the guiding principles to determine what these things mean? How do we say, if you're the judge and someone comes to you and says, this violates my privileges and immunities, and the 14th Amendment guarantees those, what do you turn to look at those? And we have people talk about original intent, and some would say, just look to when the Constitution was created. And I think, Michael, you'd say, well, yes, the Constitution was created, but it was amended. That intent and meaning changed. Go to the current meaning based on amendments, because that becomes part of the Constitution.
Yeah, that's exactly right. The meaning seems to change over time if you take an amendment. And it gets back to the question of, well, then, what are we going to go with logically? How does everybody agree? If we're just going to rely on the words or the logic, it seems to me that there still is a lot of room for arguments in a lot of different ways. I think sometimes we make that mistake today where so much information is available so readily. We think if we can just get enough information, if we could just have the facts, then we'll find what the answer is. And it's pretty clear that's not the case. There's information readily available. Everybody reads the same information and comes away with 100 different interpretations. I think we need to do a better job of discussing what is the moral principle we're trying to address. And it's a difficult conversation. We don't talk about our morals enough, I think, to be really comfortable. because they're not grounded in what we would call traditional facts, generally speaking. They're grounded in what we believe in. And so we tend to avoid the conversations about what we believe, fearing that that's not a good justification for a law or something along those lines. However, that's every justification. Every law is based on some sort of moral belief about what is right and wrong. And so at some point, we need to get better at saying, I'm coming at it from this moral perspective and stating, this is how I feel about it morally. And this is kind of driving the way I'm interpreting what I'm reading. And then you can have a discussion about, what is the moral principle there. And I think that will have people arrive at conclusions a lot faster, whether they agree or not. That still will be disagreements, but they'll understand. I morally think this and you morally think that, or actually morally we agree and we've just been interpreting the words quite differently, but we have the same moral value. I think it'll go a long way to address a lot of confusion that we have over laws. And I think the second point there is, consider these laws we're reading about. I don't know the years these passed exactly, obviously after the Civil War, but we're still discussing them today and trying to figure out what they mean. I think it's a good lesson to us when we look at laws written by Congress or interpreted by Supreme Court to be careful what we're writing. Anything you write down gets put on the books, and then we'll talk about it for 100, 200 years. And so when we make laws that are massive laws that have changes everywhere, are we going to argue about all of these in every court case for the next thousands of years, or should we be a little more circumspect in the laws that we pass, knowing that when you write something down, it's difficult to understand, it's difficult to interpret. We maybe should use more care when writing large laws. I think specifically of maybe some very large federal bills that I've seen passed that just have page after page of rules and regulation, and you think, are we going to litigate all that? And we probably will. And so I guess that's just a lesson to me to take care in how we write laws.
Yeah, and it's a great point. I'll actually share my screen on something else that I was looking at today. So if you're just listening on the just listening, you won't be able to see this, but for those that have the video, this is an example of a federal law. The government passes quite a few of these. And this was the National Defense Authorization Act for fiscal year 2021. If you come here, it starts with these sections. They do skip some. So section 113 then goes to 121 because a new subtitle starts. But what we're seeing on the screen here is just an outline of what's in this law that was passed. This law has an incredible number of provisions in it. These sections go on into the thousands and thousands. And they go through all kinds of things. They go through icebreakers, funding icebreakers. They go through mental health type things. Financial assistance under my career advancement account program, military child care and child development center matters. But it gets into a lot more than military. At the beginning, there's a lot of military items. We still are passing, this was 2020, there was COVID stuff. We've got the Wounded Warrior Service Dog Program. We've got briefing on diet and nutrition. And when you start scrolling through this, if you can see on the screen, over here on the right, this little bar, it's barely moved and we're down at 1,000. The federal government's passing an incredible number of laws. In this law particularly that we're looking at, they passed what they call the Corporate Transparency Act. And the Corporate Transparency Act is one that imposes quite a few burdens on small business owners and makes them criminals if they don't provide certain information to the federal government that they never had to provide before. And it's just housed down at section 6,000 something in this bill, We've got the Global Child Thrive Act of 2020, where apparently the U.S. is working on global matters for orphans and others. We got space activities, strategic programs, nuclear forces, missile defense programs, cybersecurity, related matters. This just goes on and on and on and on as we look at it. You get to these, down here in section 9,000, semiconductor incentives, ensuring Chinese debt transparency, accountability for World Bank loans to China, all kinds of stuff that if you look at it, cybersecurity and STEM programs, the Internet of Things, they actually have a provision in here where they're trying to set up the Internet of Things, trying to make that happen. But I bring this up because as we look at the federal government or government in general, and to your point, Michael, about language, these things are so expansive and there are so many provisions. Obviously, they plan on the judges interpreting some of them, but nothing is written well enough to have all the details in it. And so we do rely on judges to fill in the holes, to resolve ambiguities, because it's virtually impossible to pass a bill like this without some ambiguity in there. And then what do we do after that? How are these judges doing that? And we get upset about these things because we say these judges are legislating from the bench. And I look at it and say, well, maybe it's because we haven't agreed on our morals as a country. And that's something that we really need to do. Curious if you have any more thoughts on that, Michael.
I think that's exactly right. It's too often that we're, you could go through that bill and you could say, this seems like a good thing to do. That seems like a good thing to do. And forgetting that there are an infinite number of good things to do in the world. We need to, as a country, come together and say, morally speaking, what are our priorities? A government, a people, they're limited so much in what they can and can accomplish. And so we need to be able to say, first of all, we need this from our government and we need this from our citizens. And this is kind of a moral decision. But too often, all we want to do is talk about what's the next good thing that we can focus on. And there's arguments about whether the thing is good or not. But let's just suppose that everything everybody is proposing that we do is a good thing. We could spend, the next eternity working on the good things and not accomplish all of them. There's just no possible way for a government to do that. And so we need to come together and say, what is the moral basis for what we're doing? We can work on good things till the end of time and still people will suffer. We need to figure out what the purpose of the government is, morally speaking, and what our responsibilities as citizens are. And those are just discussions we don't have. We want to talk about who's going to get money next, who's going to benefit, who's not going to benefit. Those are the only discussions we want to talk about. It's always good for someone to benefit, but we need to discuss, morally speaking, what is the purpose of the government.
Yeah, and I agree with that. And I know here in Utah, which is a traditionally conservative Republican state, if I go up to the Capitol, they wanted to, a few years ago, they tried to pass a sales tax on services to force us to pay, if we got a service done, to pay sales tax on it, and the service provider to collect sales tax. And the justification put forward was, the guy sponsoring the bill said, he said, every year up here at the legislature, I get $700 to $800 million in funding requests that I can't fulfill. It says we need more money. And I looked at that and said, maybe it's a good thing that we have a budget. Maybe it's a good thing that we're picking priorities and saying, I'm not a blank check. Is that the government's job to be a blank check? And I like what you say about, let's just have the conversation. What are our moral values as a country? What is the purpose of law? Is it just to benefit people, to say, oh, well, you had a powerful enough lobbyist to get this slipped into this national defense bill, so boom, you get a bunch of money for your new icebreaker or whatever. Or, oh, you want funding for polar research? Sure, here's a bunch of money from the government. go do it. These things come because we're losing our moral bearing as a country. And then we get angry at the judges for legislating from the bench, but we've left them the job of resolving the ambiguities in the Constitution and law. They have to decide what are the privileges and immunities, what is due process. And when it comes down to that, if we haven't established a moral structure that we operate under, we're going to get cases all over the place. And I think that's part of what's happening right now. And one reason why people get so upset at the judiciary is because they're saying they're legislating from the bench. And what that means, in my opinion, is that the person saying that morally disagrees with the moral positions taken by the judge, ultimately. And then we accuse them of writing things in the Constitution that aren't there. But the Constitution doesn't have a lot. It's just a basic framework, a lot of words that need a lot of meaning. And when we shy away from the discussions about, well, what is morality? What is our moral basis as a nation? We're susceptible to just, this judge says this judge says this. It's all over the place till the Supreme Court says something. And even that's just up in the air because we appoint people specifically who have very different moral bases, but we don't talk about that. We call them political views, but it's really a moral basis. And in closing with this, it is interesting to see the things that the Supreme Court has kind of held is a privilege or an immunity of citizenship. And one of those, and this is one that I think arguably is a strong US tradition, but there was a case where a native-born youth, he was Japanese, had his parents purchased him property, or they advanced money so he could buy property. His parents were ineligible for citizenship, and there was a state alien land law that prohibited non-citizens from owning land. And so the state was coming to take this property from this guy, or this youth. And the Supreme Court in that case said, yeah, property ownership is one of those privileges that all American citizens have. Now, people can point to the Declaration of Independence, and they have some arguments for it there. But the whole notion of property ownership is something that's still derived kind of at a moral level and independent in a lot of ways of the Constitution. And again, the Supreme Court recognized it. And it's one of the principles that I think has been very strongly protected. It's one of the morals that we've agreed on over time that we are talking about in our country. One of our morals is private property ownership. And that has helped make America what it is, helped make our economy what it is. But it creates a very powerful set of precedent when we do the same for other things and go through those. And I believe that that's part of the work of what we have to do as citizens. And this is where we have power as citizens in shaping the constitutional interpretations, because we can, as we advocate strongly for moral positions, those eventually appear in Supreme Court decisions. That's why the Supreme Court eventually adopted the Bill of Rights as applying to the states. People continue to argue for it. They continue to press for it. You look at Roe v. Wade, no matter what side you fall on that, people kept talking about it. They didn't stop. And that decision got reversed after 50 years. We have the ability to help set the tone of what's moral and what's not moral based on how we act and what we talk about. And that fundamentally transcends into our Constitution and how it's interpreted by the courts. So we appreciate you being with us today to talk about this little line in the 14th Amendment that hasn't been given a whole lot of weight, but that we think really illustrates the need to focus on, talk about the morality that governs how we interpret the Constitution. And so we will follow up and continue these discussions and look forward to joining with you again next week. Thanks so much.